So in the previous lesson, we talked about the certainty of intention, which is the first of the major certainties required for the creation of an express trust. In this lesson, we're going to talk about the certainty of subject matter, the idea of being able to clearly delineate the kind of property which can and cannot be held on trust. So essentially, that's what we're going to do. And when it comes to the idea of the kinds of things that can be put on trust, this is where we have a number of different issues, okay? And there are plenty of cases which essentially illustrates different kinds of properties which may or may not be able to be put on trust. So when we refer to the idea of the certainty of subject matter, that is what we're talking about. We're talking about what the property is in question that is going to be held on trust by the trustee for the benefit of a beneficiary. So it's the thing that the settlor or the testator is transferring legal title to the trustee. Now, generally speaking, the certainty of subject matter can be satisfied by examining essentially the vast majority of different kinds of property. It can include land, it can include money, like a bank account, it can include personal goods, so your laptop, TVs. It can include securities, so debt and equity securities. So, for example, stocks and shares in a company or bonds in a corporation. It can include any of those things, okay? It could also include copyright. Future property or the acquisition of new property, however, can never be the kinds of property that can exist on trust. You have to have the ability to put on trust a thing that exists at the time at which you are creating the trust. Okay, so this may be tangible or intangible. So it could be a security in a company, or it could be land, or it could be money. It could be movable or immovable, but it has to be something that you have. It can't be the idea of property in the future being held on trust for somebody. That does not represent the certainty of subject matter. It doesn't represent the certainty of ownership of your own property, because you're not certain that you're going to acquire new property. And so this must be distinguished from the existing property in question. So you have to very clearly demarcate what the property is. What is this property? What isn't the property? Okay? And what I'm going to intend to put on trust. The main consideration here is that the subject matter for the trust should be clearly identifiable. I should be able to have a look at it and go, that's a property. So if I was to wanted to put my laptop on trust, that's clearly a very easy thing to do to satisfy the certainty of subject matter. My laptop is a very clear piece of property. It is clearly delineated. It is not your laptop. It is not the concept of laptops generally. It is a specific item that I own. I could even go deeper and name the specific brand laptop, the specific item as well, and say this is going to be held on trust. And so as a result of which, that would represent a certainty of subject matter. Let's think about some of the interesting cases which challenge the idea of certainty of subject matter. The first one is the London Wine Corporation case. Ultimately, what this was a case about was a case which involved a wine dealer who was the defendant, and they had sold wine, lots of different bottles of wine, lots of different crates of wine or whatever, to a variety of different customers, okay, as you would expect being a wine dealer. The sale of the wine was made through contracts, and the wine would be kept in the warehouse of the defendant. So ownership of the wine was shown and certified through these contractual arrangements, okay? Now, the customers would be given certificates of title to the wine, and they would also be charged for the storage of the wine as insurance, okay? So they would pay for the storage of the wine in this warehouse, and they would be given certificates of what the wine is, okay? You own this wine. Now, the thing to note about this particular case, and the thing that is so critical for the certainty of subject matter, is that the wine would not be delineated from each customer. There was no indication as to which exact bottle of wine each customer owned. So let's say there was two customers and they both owned 2 bottles of Pinot Grigio each, okay? The problem here is the bottles of Pinot Grigio, there would be 4 bottles of Pinot Grigio, and there would be 2 certificates that says you own 2 bottles of this Pinot Grigio, and you own 2 bottles of Pinot Grigio as well. But if we were to look at the 4 bottles of Pinot Grigio that were in the warehouse, it was not clear which of the 4 belonged to the first customer and then which of the 4 belonged to the other customer. So how were you able to delineate it? You aren't going to be able to delineate it. All that was known was that you had ownership by the way of these certificates, but we didn't know which specific bottles you could find and pick out. There weren't labels on the bottles that matched the certificate of title to a customer, for example. So the question here is, when the defendant goes into liquidation, and the defendant goes insolvent, and a liquidator comes and wants to start selling off assets to pay off creditors, the question of property was established. Because the customers argued that the wine was actually theirs, they had equitable title to the property, to the wine, and it was being held held on trust by the defendant for them as beneficiaries. And so as a result of which, it would mean that the liquidator had no ability to actually go about and sell that property off, because it wasn't their property. It wasn't even the defendant's property either. They no longer had equitable title. And so it would protect against creditors who sought recovery when the company went into insolvency. So it's very important, because if this wasn't established, then it would mean that the liquidator had the ability to take that wine and to sell it off for the creditors. Now, the courts held that because there was no way to clearly delimit who owned which bottles of wine, the claim failed on the basis of there was a lack of sufficient subject matter. Justice Oliver argued that I cannot see how, for instance, a farmer who declares himself the trustee of 2 sheep without identifying them can be said to have created a perfect trust. So if there was a field full of about 1,000 sheep, okay, massive field, and a sheep farmer comes along and says, I own 2 of them, and the response is, well, which 2 do you own? And he says, well, I don't know, I just own 2 sheep, okay. How can that create a perfect trust for certainty of subject matter? In a similar way, in a warehouse full of bottles of wine, a customer can go along with a certificate and say, I own 2 bottles of this wine in this warehouse. I've got a certificate that proves it. I've bought it. I've paid for it. I've paid for it by insurance or whatever. And they go, okay, well, which 2 bottles? Well, I don't know, because they can't clearly delimit who owns which bottle of wine. That is the point of this case. Hunter and Moss from 1994 is actually quite a similar case, but it actually rules in a different way. Because the defendant in this case had owned 950 of the 1,000 shares that existed in the company, so a significant majority of the corporation. They had made an oral declaration of 50 shares to the claimant to be held on trust, and this represented about 5% of the share capital. Now, the issues here was, if we were to apply the ruling in the London Wine Corporation, you could make the argument that, because we're not able to clearly identify each share, there must surely be a lack of sufficient subject matter, or sufficient certainty of subject matter. Because in the same way that the customers couldn't clearly label and delimit which of the bottles of wine were theirs, you can't go and clearly limit and delimit which of the shares of these 50 shares from the 1,000 or from the 950 were yours. And so, in applying Re London Wine Corporation, that is the answer that you would get. But it was held that this case is different to the Wine Corporation case. And the reason why is because there had been the passing of property in chattel in the first example, and this is the passing of property by way of security in a company in the second example. So the reason why it's different is because the intangible assets, such as shares, shouldn't need to be clearly delimited from the rest of the subject matter of the trust, because ultimately there is no way of being able to tell the difference of shares in a corporation. In Re London Wine Corporation, it could have been very easily the case that when a customer purchases a bottle of wine and that bottle of wine is then held in the warehouse, the defendant could have put a little label on that bottle of wine to clearly mark out who owns that bottle. You can't do that with shares, because if you just say I have 50 shares of the 950 of a company, a share is a share. They are undistinguishable from the rest, okay? And it would also mean, so as a result of which, Hunter and Moss, it was held that there was a valid trust here. But it would also mean that if we were to apply Re London Wine Corporation, then pretty much any other case which involved shares being held on trust would fail, and so therefore shares would not be able to represent trust, the property on trust. So that doesn't seem to make much sense. In continuing then, let's have a look at this idea of the Gold Corp Exchange case from 1995. This case gives us a clear delineation between the Re London Wine case and the Hunter and Moss case, because in this case, the idea of chattel which is homogeneous is the question of subject matter, okay? So it sort of sits in the middle between Hunter and Moss and London Wine Corporation, because in Hunter and Moss, you had intangible property, which was homogeneous, and in London Wine Corporation, you had chattel, which was non-homogeneous. Well, now we have a case where we have chattel, which is homogeneous, okay? The questions in this case revolved around the idea of gold bullion, which formed the subject matter. The sellers of the bullion had given the customers certificates of title in a very similar way to the London Wine case, but they had also not segregated the property, again, just like London Wine Corporation. And again, just like London Wine Corporation, when the company goes insolvent, the customers who have this certificate of title want to be able to protect their assets from the creditors who are going to try and take this gold bullion and sell it off to appease the creditors. And so they wanted to argue that they had beneficial rights to that gold bullion. And it was held that no trust was created owing to this lack of subject matter. The case involved homogeneous property, okay? Homogeneous property being like the case of Hunter and Moss. But the type of property was a chattel. And so, in this case, it was made clear that the certainty of subject matter could not be determined. So even if it is homogeneous property, like Hunter and Moss, but it is still chattel nevertheless, that could clearly be delineated, it could clearly be segregated, even if it was homogeneous, therefore it means there was no subject matter, or there was a lack of certainty of subject matter.